Kdo jsem? Já jsem ten, kdo může být 100 různými investory. Najednou. Z eToro mohu být Grace, globální investorka v oblasti technologií. Nebo Mark.
Continuing wrong doctrine did apply, it still doesn't allow the trial court to do what it did, which is to go way back in time to 2011 and 2012 and assign liability and major consequences, huge financial consequences, based on an analysis that never looked at a 2017 or 2015 statement and said what liability flows from just that statement that comes much later in the course of conduct.
And loans which closed long ago.
Exactly right, Your Honor. And again, this court addressed this squarely in the Henry decision, which is cited in Trump 1, the CW Capital decision, which is cited in Trump 1. What Henry says is, even if you apply the doctrine, it only applies to allow liability for statements within the limitations period. But that's not what the trial court did here. That's not what the Attorney General's office contended. They said, oh, we're going to apply the continuing wrong doctrine. That contradicts Trump 1, so that was the first error. But then the second error is, once we've done that, we're going to pretend there's no statute of limitations at all. And we're going to go all the way back in time and assign crippling financial liability for transactions that concluded again in 2011 and 2012. So there's a direct contradiction, a direct disregard of the prior, this court's prior opinion. It becomes really clear, I think, when you look at, for example, there's a citation of the Yin-Shing Lung decision by the trial court. And the trial court says this shows this is a continuous series of wrongs, each of which gives rise to its own liability, when there was an opinion from this court 3 months earlier saying the continuing wrong doctrine does not apply. That makes it very clear.
But again, shouldn't we have said, or wouldn't we have said, these statements of financial condition that fall within the limitations period don't give rise to a 6312 claim? Shouldn't we have just said that? Would have saved everyone a lot of time.
I think that's clearly what the continuing wrong doctrine means if you apply it. And again, the dismissal of Ms. Trump strongly supports that. But in any event, Your Honor, even if the court doesn't agree with that, there's still a massive violation of the continuing of the statute of limitations, because again, under Henry and versus Bank of America and under the CW Capital decision, the most the trial court could have done is looked at the 2017 statements and said, what liability can I assess to that? Can I oppose to that? And that is not at all what happened in the trial court. There was just a complete disregard of statute of limitations and an analysis that again and again goes all the way back to 2012.
Even if we agree with you on the statute of limitations point, that would not result in the complaint in its entirety being dismissed. There would still be several transactions that would be not time barred or timely. So what is your response to, or what is your strongest argument as to for dismissal of those claims, those exited non-time barred claims?
Right, there would be 2 of the 10 that were charged in the complaint that we've identified that would only apply to those covered by the tolling agreement. Like Ms. Trump, if you're not covered by the tolling agreement, it's all gone, essentially. But in answer to your Honor's question, we argue that there was a complete failure of proof on the critical element of capacity or tendency to deceive, which is an element required of any 6312.
Well, I can stop you there. Are you talking about a failure of proof at trial?
Absolutely, Your Honor, as well as in summary judgment. So we raised this.
Okay, but cause of action number 1, which is the fraud-based claim under 6312, liability on that was not tried, right? That was determined at summary judgment.
That is correct, Your Honor.
Okay,
and so we challenge it as to both, yes.
I don't believe we can look at the trial record to answer any questions about the sufficiency of cause of action number 1 based on fraud. Don't we have to confine our review to the summary judgment motion record?
Well, to the extent that the trial court in the final decision was repeatedly referring to reinforce its prior holding in summary judgment, yes. Now, our position, of course, is that the failure of proof is even more defined, even more clear when you look at the summary judgment record. For example, just a couple citations to put this in context. Summary judgment record, page 13965 of the record, is a Deutsche Bank witness, uncontradicted, saying if his net worth had been as low as $1 billion, for example, he would have gotten exactly the same deal. It would have been exactly the same transaction. That's uncontradicted. It's reinforced by the trial testimony.
But could the trial court have credited Mr. Hayes' statement? He's also a Deutsche Bank employee, correct? And he said that if the facts were, if the SFCs were incorrect, then they didn't properly assess the risk on these loans. Mr. Hayes said that. You would say that in your brief, I believe.
He made a much more generic, if you look at that particular citation, he made a much more generic content that we want to make sure we're being, compensated for our risk. What is not disputed is the testimony that if the net worth had been as low as $1 billion, and again, this is the testimony of Williams, if the net worth had been as low as $1 billion, the deal would have been exactly the same. And so it's astonishing if you look at, for example, page 1882 of the record, which is their schematic that they cite 9 times in their brief, they concede that President Trump's net worth ranged between, on their view, $3 billion and $4.7 billion throughout this entire period, which is miles above.
If you're talking about summary judgment, isn't it basic that you don't make credibility determinations on the motion?
Absolutely correct, Your Honor, and we have a repeated violation of that, as we point out in our briefing. For example, there's sort of kind of astonishing credibility determinations to disregard unrebutted in the summary judgment record expert testimony. So if you look at 17.916, the summary judgment affidavits of Bartoff, where he explains how all these representations, virtually everything they challenge, is consistent with generally applicable accounting standards. They're GAAP compliant statements. That's unrebutted in the summary judgment record. It goes beyond merely being disputed and you couldn't decide it by a credibility determination. There's really nothing to the contrary. And again, these errors are all reinforced at trial, so we are challenging both of those. And if you look particularly at Professor Bartoff's testimony, you have this clear explanation that all the things that they say are misleading are things that are specifically approved in ASC 274.
Creating an issue of fact. Correct?
Exactly right, Your Honor. That's exactly right, Your Honor. That's at the very least, that's a disputed issue of fact. It isn't just Professor Bartoff. There's a whole series. There's Professor Flemons. There's a whole series of experts. When you get to, yes, Your Honor.
Well, you finished that, but then I have a question for you about the scope of the statute.
Go right ahead, Your Honor.
Okay. Yeah. No, so just looking at the language of the statute, it says that it's enacted to promote the honesty and integrity in commercial marketplace in New York by stopping fraud and illegal business. So to accomplish this, the statute authorizes the Attorney General that whenever a person shall engage in repeated fraudulent, I know that you're challenging that, or illegal acts, that they can bring such an action. So why isn't the language of the statute here referring to the repeated and fraudulent illegal acts or persistent fraud or legality? Why doesn't that define the scope of the statute? Why do we need to go to harm or threat of harm?
Yes, Your Honor. So the standard is that, as this court held, for example, in General Electric, is there has to be a capacity or tendency to deceive or atmosphere conducive to fraud. And what we've pointed out is that you have a situation where there were no victims, no complaints, no evidence of causation, materiality, or reliance. There were sophisticated counterparties who, the understanding of the relevant marketplace, as this court said in the Nordbank decision, understood that they would be doing their due diligence. They did do their own due diligence. The uncontradicted testimony in the summary judgment record is everything we did was independent. We didn't rely on the numbers. That's the Williams testimony in the summary judgment record. All that is evidence, for example, the Domino's Pizza decision that we've cited powerfully makes this point, where all of that is lacking. All that is powerful evidence that there was no capacity or tendency to deceive, which ties into our point that every single one of these transactions would have looked exactly the same.
I'm sorry, counsel. What about deterrence? In other words, the AG would have the argument that maybe these deals went down fine as far as all the parties were concerned in these deals, but in the future, some deal might not go down well, and someone would be harmed by that. And so we need to deter parties from putting in, fallacious statements of financial whatever. Go ahead.
May I respond?
Yes.
Red light. Just to answer that question, the deterrence interest goes entirely the opposite direction, where we have a situation where the Supreme Court disregarded unrebutted expert testimony that these are GAAP compliant. These are consistent with accounting standards, which don't require perfection.
No, but the Attorney General points out that whether or not they're consistent with GAAP principles, it's the factual inaccuracies that are important. So, in other words, you might be following GAAP principles, but if your data is terrible, then you're creating a fallacious statement.
With respect to that, that disregards or at least misinterprets our expert testimony, which look at what they say is factual data that's misinterpreted. For example, appraisals. Essentially, the Supreme Court said if you got an appraisal in your file, you got to rely on that. You can't rely on your own independent judgment. They say that's a factual inaccuracy. GAAP says the opposite. At least that's the unrebutted testimony in the summary judgment record. And I would direct the court to page 17916, the beginning of Professor Bartoff's summary of opinions on that.
I want to turn your attention to a different subject because your red light is on. I'm trying to figure out about the valuation of Mar-a-Lago. I noticed that your expert, Mr. Mones, valued it at over $1 billion. He also said that if it was in the hands of a new owner, club memberships, 500 club memberships could be sold, generating $250 million, and it generates revenue of over $50 million a year in 2022 and 2023. And Supreme Court values it at $18 to $27 million because of restrictions. Do you have anything to say about those restrictions taking it down in value to such an extent?
I'd say two things in response to that. First, the Shubin affidavit directly addresses that. That was improperly kind of disregarded.
He says there are no restrictions on it. He says there aren't. Shubin says there are no restrictions.
He says you have to interpret. He says the trial court looks at one document in isolation, the deed of conservation. Mr. Shubin says you got to look at all 5 documents, including the historical practice there, to understand what the actual policy is. And for example, they say he couldn't value it as a private residence, but he's been using it as a private residence since 1995, continuously to this day. But the more fundamental point is that valuation, where he relied on a tax assessment, illustrates the hazards to the marketplace as a whole here from having the Supreme Court cite things like Chico Marx in footnote 9 of the summary judgment position, the I know it when I see it standard from obscenity law from Justice Potter Stewart to decide what's a misrepresentation in these statements. When you have expert testimony unrebutted that says these are gap consistent, if we have a system where you can issue perfectly accounting clear and basically statements that comply with gap, and you're held, well, we have another standard, I know it when I see it, that's good, that's bad. People can't do business in real estate. So,
Thank you.
thank you, Your Honor.
Oh, I'm sorry. There's another question.
Oh.
Sir, are you asking us to draw any bright line rules as to the contour of the AG's authority under 6312, or are you asking us to scrutinize the evidence that was adduced either at summary judgment with respect to claim number 1 and then at trial with respect to 2 through 7?
The latter, Your Honor. So our argument is on the unique facts of this case, you cannot come to the conclusion that the plain language of the statute was violated. And we argue, obviously, that it raises constitutional questions as well under Grasso and under the excessive fines clause and so forth. We make all those interpretive arguments. But the fundamental point is, if you look at these unique facts on this case, the statute just doesn't cover it. And if it does, it has no limitation.
It's your position that under the facts of this case, 6312 didn't support the taking the action that was taken.
That's exactly right, Your Honor. Thank you, Your Honor.
Good afternoon, Your Honors. Brian Isaac, as you know, I represent the non-party appellant attorneys. My argument is not as sexy as the other arguments, but I think it's a hugely important argument to me as an appellate litigator. I think that the New York State judicial system is the best in the world. I don't think it's better arithmetically. I think it's better geometrically. And I think most of the credit goes to you, but some of it goes to us also. You can't do your job in an exemplary fashion unless we do our job competently. And every single lawyer who practices in New York knows it's not what you get at the trial level, it's what you keep in the appellate division. It is an absolutely horrible idea, in my judgment, to sanction attorneys for making motions for summary judgment in cases where they have to do it to preserve the issue, not only here, Your Honors.
You don't want to take a chance on the appellate court saying, oh, they didn't preserve the issue.
Judge, it's not only here. This is a Trump case. Like him, don't like him, it doesn't matter. This case is a case that definitionally could go to the Court of Appeals. Look at 522B41, look at Cialina against Erie Preserve, look at the number of amicus briefs that you had. I couldn't even read them. You have to preserve these issues. And there's one fact that I want to bring to your attention. I know you know it, but we probably should have brought it out in the brief more. You have interest of justice jurisdiction. You can, if you want, decide unpreserved issues. You almost never do it if you don't believe me. Just run my name. Just put Brian J. Isaac, in quotes, within 8, put preserved, unpreserved, not preserved. See how good I've been. I'm not 0 for 5. I'm not 0 for 10. I'm 0 for 3 decades on that. But this court can do it. The Court of Appeals can't. They do not have any interest of justice jurisdiction. They are not allowed to decide mixed questions of law and fact. They can't decide damage issues. They can't decide that a case is against the credible weight of the evidence. How can a competent attorney, and these people are competent attorneys, risk a $440 million malpractice claim by not raising an argument that's a tenable argument. And I'm not going to go over my time because I don't, but I wanted to say something to you. The Attorney General and the trial judge excoriated the lawyers for making a motion for summary judgment on disgorgement at the summary judgment level. One of the cases they rely on is People against Ernst & Young, which you know. Can I read to you what you said? This isn't Brian Isaac. It's not Michael Ross who wrote the brief for me. This is the Appellate Division First Department. I'm reading it verbatim. Quote, therefore, while the Attorney General does not allege direct injury to the public or consumers as a result of defendants' alleged collusion with Lehman Brothers in committing fraud, the equitable remedy of disgorgement is available in this action. Here's the key point. And it was premature to categorically preclude it at the pleading stage. That's verbatim. That is exactly what these lawyers did. And to be sanctioned for it is just wrong and threatens the integrity of what I think is the greatest juridical system we've seen. You shouldn't allow it.
Thank you. Counsel. So you have 10 minutes on this first. You have 10 minutes on this.
Well, I don't know if it's easier, Your Honor. Since we're the appellees, I'm happy to just take the full 15 minutes as the appellee, and that
Okay.
I think that maybe simplifies things.
Yes.
May it please the Court, Judith Vale for the New York Attorney General's Office. All of the defendants repeatedly
Ms.
violated.
Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners, where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented
Lounge bych popsal jako dobrý nákup.
Big news! Today we are launching the Beat the Retail Nonsense Trading Challenge 2024. Now you're wondering what that's about. I'll tell you exactly what that's about. Now I've put together a brand new professional trading webinar to show you.
Robin's Cup. Like that's a fucking challenge. I am going to win that. I don't know why you guys are sitting here pretending like I forgot about it. I didn't forget about it. I know exactly what the fuck I'm doing. I'm going to part the Red Sea and I'm running to the top of that motherfucker and none of you are going to be near me. So get your sound bites out of that because that's what's coming. And yes, I'm going to win the Robin's Cup, so stop sending me emails, okay? It's in the bag. Trust me on that. Okay, I told you all I would give you a drama. I'll give you a tragedy. But at the end of the year, it's my name at the top of that list. Okay, so just relax. Keep making your videos because you look stupid. Exposed ICT failed Robin's Cup. It's just gonna make it even better. Here's what happened. I went into the Robin's Cup and I sat there and I pushed and 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 I pushed that fucking account down to $900 fucking dollars.
Do I sound like I'm embarrassed? No. Think about it, folks.
But do you honestly, okay, seriously, sincerely mean this, okay? Do you think it's hard to make 400%? It's fucking easy. You didn't win the Robin's Cup ICT, but some of you think that that's the litmus test that says, see, he's a fraud. because I gave you that invitation to think that.
To not a single non-beginner trader surprise, ICT just announced that his 2024 Robbins Cup account is down 91% from its $10,000 starting balance. Of course, the best part is the insane 20-minute rant afterwards about how it's not his fault, but we'll laugh at that in just a sec.
I'm gonna